Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Voir Dire, in the case styled as Idaho versus Kohberger, will commence July 30th, 2025 at 9 o'clock a.m. per Judge Stephen J. Hippler's October 9th, 2024 pretrial and trial order. And although there's nothing here that says that Voir Dire will be closed to the public, I believe that there exists a possibility that it might be. I want to express why I feel Voir Dire should be open to the public. First and foremost, the enormous tragedy that occurred at 1122 King Road on November 13th, 2022, I believe impacts, of course, the students themselves and their families and friends, but beyond that, their community, their state, and their country. Because in a matter of moments when their lives were taken, it changed the lives forever of their families who've been left to mourn them and have a loss that no one should ever in their lives experience, I believe. But there's also the loss to what these students who were attending college to better themselves might have made to their local community, to their state, and to their nation in the years and the decades that were taken in just a matter of minutes on November 13th, 2022. And then there's also a defendant who is presumed innocent until or unless he either pleads guilty or is adjudicated guilty. Mr. Kohberger is cloaked with the presumption of innocence. And there's his family that have been impacted. In addition, all of the things that this case stands for, the proposition that a case could be largely under seal for a very long time, as this case was. We have only just started to understand some of the evidence in the case as to why the state feels Mr. Kohberger is the sole and the correct defendant, and why the defense feels just the opposite. There's been a gag order that's been in place since January 3rd, 2023. Mr. Kohberger was arrested December 30th, 2022. So it's basically from the very start of the case that both sides wanted, they sought, in terms of a stipulation that they submitted to the judge who was presiding over the case at that time, Magistrate Judge Megan E. Marshall. And since then, in one way or another, there's been a gag order that has prevented the sorts of things that you see in other high-profile cases, such as once in a while, law enforcement giving an interview, or defense counsel giving an interview, or prosecution giving an interview and updating the public as to how they believe the case is proceeding. We have not seen one such interview like that. Compare that to other high-profile cases, and you'll understand that that is not the norm. And then on top of that, what I call Mount Everest of documents that have been under seal since the beginning, and it is only until you look at the case summary page, which documents all of the key events of the case since the inception, and you see all of the icons next to entries that are lock and key, that tells you that that is a sealed and closed document that the public has no access to, versus PDF icon, which tells us that those documents have been released to the public on the docket. I'm concerned about the precedent that this case is making in terms of the First Amendment to the United States Constitution as both a citizen of the United States and a podcaster, freedom of speech and of the press. And if so many things are closed to the public, the press can't report on it, and the public is not aware of it. And as we look at the Bill of Rights and we see all of the filings that have been made in this case, they many times will cite to the Fifth Amendment, to the Sixth Amendment, to the 14th Amendment Due Process Clause. But before all of those come the First Amendment, and I would in my opinion, I believe that there was a reason why the framers of the Constitution put the First Amendment first before anything else. I believe it is immensely important to our form of government. Another reason why I believe it should be open to the public voir dire jury selection is because of a 41-year case that was decided by the United States Supreme Court that has ultimate authority to interpret the Constitution of the United States and what it means. It is a case called Press Enterprise Company versus Superior Court. It is from 1984, and there the Supreme Court held that the First Amendment to the United States Constitution creates a presumption in favor of public access to voir dire proceedings in criminal cases where the examination of potential jurors happens. States, as this case indicates, through their courts, may limit or deny this right of access of the public to voir dire proceedings, but only where such a restriction is necessary by some other compelling interest in the preservation of higher values. Court also, in that case, from 1984, Press Enterprise Company versus Superior Court found that any such restriction of the public's access to voir dire in criminal proceedings must be narrowly tailored to preserve that compelling interest that is created by the First Amendment. In this case, in addition to everything that has been under seal and all of the hearings that have been closed to the public since the beginning of the case, and there have been many, you'll see it by looking at the case summary page, and all of the discovery and all of the filings that have been under seal, meaning that the public has no access to it. Judge Stephen J. Hippler in early 2025 found that more items should be made public, and it is only because of that position that we, the public, have now been the recipients of and privy to some of the discovery that the state has filed and that the defense has filed. Discovery as evidence, and some other matters, including a transcript from a closed hearing on January 23rd, 2025, and other related information. But in contrast to that position, we have seen quite a few things that relate to trial sealed from the public, including jury instructions and any objections that one side has to proposed jury instructions that the other side submitted. There was nothing in the court order of October 9th, 2024 that directed the parties were to file their proposed jury instructions or their objections thereto under seal. And I, for one, do not understand why it is that when the court ordered and granted those requests, every single jury instruction was sealed from the public. Jury instructions are legal documents. They're not necessarily unique to this case. When a jury is instructed as to what the presumption of innocence is, or what direct versus indirect evidence is, or what the prosecution's burden of proof is, that is something that's applicable to every single criminal proceeding, not just this case. If there was something, some jury instruction that had some compelling reason that should be filed under seal, that's one thing. But to blanket file all of them under seal, I do not understand. I give my opinion, as I say, thanks to the First Amendment of the United States Constitution, when I do say I do not understand why every single jury instruction that was never directed by the parties to be filed under seal have been, and that the court agreed with those motions to file them under seal. And that is the reason why we do not have access to jury instructions. And so with the other things related to the trial, such as witness lists, such as the exhibit lists, such as jury questionnaires also being under seal, I fear that Voir Dire proceeding may also ultimately be determined to be under seal. We're going to have to wait and see if Judge Hippler issues some type of an order regarding whether Voir Dire will be open or closed, and keep open the possibility that just as the parties went to the court at the beginning of the case together and filed a stipulation for that gag order, that they may together go to the court and ask for Voir Dire to be sealed, or one party may file a motion to seal Voir Dire from the public. We're going to continue to monitor the situation over this crucial part of this case, the selection of the jurors who will be not just making the ultimate decision of whether Mr. Kohberger is guilty or not guilty of the 5 first-degree felonies that he is standing trial for in this, by the way, capital case. They will be making decisions also as to the credibility of witnesses, expert trial witnesses, lay witnesses, and any other evidence that's introduced. So I do continue to believe that this should be a process that must be open to the public, and that's my opinion. If you have any questions, any comments, please leave them here. We're going to continue to monitor the docket. If we see anything related to Voir Dire, we will, of course, let you know. Until next time, this is Kathy. Thank you for joining us here today.